This is Jeremy Gruber, and I think that's quite true. I'd like to remind everyone when we've been talking about the exceptions to the rule prohibiting acquisition of information, that the rule prohibiting acquisition of information itself does not have an intentional requirement, and therefore it's going to be particularly important that examples be given for employers on how to not run a risk of violating GINA. That intentional being left out of that requirement was meant as to make sure that the exceptions were limited. If there was an intentional requirement in the rule itself, the exceptions would have almost swallowed the rule. The exceptions are not meant to swallow the rule prohibiting acquisition of genetic information. In fact, they were meant to be extremely limited, and the list that were provided in the law was meant to be exhaustive. So I would hope that the regulations provide examples of ways that employers, when they are trying to acquire information, for example, when I was talking about trying to meet a reasonable accommodation request, or after a conditional offer of employment had been made, language that employers could use to make sure that their requests did not run afoul of GINA. Otherwise, an employer could simply ask in more general terms for information with the full knowledge that genetic information is likely to be included and not be subject to the rule itself. So I'd want to make sure that affirmative language could be provided to employers so that they could protect themselves and make sure that the exceptions to the rule are very limited.
I would agree with
Jeremy, let me just say, I know you know when you raised concerns about the water cooler exception. So an example that actually maybe goes into a level of questioning by the employer after they hear something that, crosses the line would be good for employers to know. Something like that?
Yeah, exactly, because an employer, like I said, there's no intent requirement. An employer who asks for information and then acquires genetic information as a result of that request runs in violation of GINA. There's no requirement that an employer be acquiring information with the intent to discriminate. There's no rule that the employer be acquiring information with the intent to even acquire genetic information, but the fact that they are acquiring genetic information to begin with violates the rule itself.
Right.
So it's going to be particularly important that employers are provided with language so that they can make that distinction.
This is Susanna Baruch speaking, and I would endorse Jeremy's thoughts. I think it would be helpful for employers and employees alike to know that there's some guidance in place, some magic words that would help provide clarity about what are appropriate and what are inappropriate ways of approaching this issue. I think that in the context of the definitions, that's another area where specific examples are going to be very helpful. One issue that has come up is, well, what does a manifest disease mean exactly in the context of genetic testing, where in some cases in medical practice a genetic test can actually be used to confirm a diagnosis where a patient is already showing signs and symptoms. So an example that says that the presence of signs and symptoms has to be there for a genetic test to be taken out of the protection would be a helpful example to give of what is meant.
Okay. Great, thank you. I can't see that fabulous little timer there with the lights on it. So is it all right if I proceed with one more question?
let me turn to Commissioner Barker first, and then I'll come back
Okay.
to you.
I'll defer to Chris if she wants to go ahead and do that.
Commissioner Barker has deferred to you on the phone. Go ahead.
Well, the other thing I wanted to get a little more discussion about is the issue that Andy you raised around training. I am proudly a product of the original ADA network training that the EEOC and the Department of Justice embarked upon when the ADA was passed, and was lucky enough to be in that train the trainer session in D.C. I was in law school at the time, and I remember thinking, God, this training is more rigorous and more difficult than most of my law school classes. It was a great training and a great opportunity, and I'd love to see us do something like that again. Can you talk a little bit about, what you were envisioning when you testified about, combining the ADA Amendments Act as well as even the Mental Health Parity Act, that I know Labor's responsible for, but maybe a little bit about how you would see that playing out?
Sure. Thank you. This is Andy with AAPD. I think, again, this is something that we at AAPD have been interested in seeing happen going back to the Clinton administration. The law has changed a lot and is changing a lot. And the notion that you would invest in major training once for a new law like this that is going to go through a lot of interpretations, it just doesn't reflect the reality of the need out there. We do have disability business technical assistance centers and other entities out there that do training, but EEOC is the expert on what these new laws mean, and I think something that has the imprimatur of EEOC is particularly powerful. And again, as Stuart alluded to, a lot has changed since the early 90s in technology too. There's a lot that EEOC can do using the internet, using different ways of disseminating information that really were just kind of getting started when the network training was done. So, Chris, I think it's a matter of, I would love to see a multi-agency effort here of really looking at what's the needs, what are the technological tools that we have available to all of us, what are the field infrastructures that we have available to all of us, and how do we leverage all of this to get this information out there in a way where we're, saturating the market, if you will, and people in the protected class know their rights. I remember the National Organization on Disability did a study, I think in '95, where they found about half of the people protected by the ADA had even heard of it. So yeah. There's definitely a need to kind of be out there letting people know what their rights are. And certainly in the genetics area, I think there are a lot of people that have gene-linked conditions that don't know that a law passed, that don't know that they have protections, and that are taking that ignorance with them when they're making decisions about whether to get a genetic test.
Yeah, great. I'd also like to remark about Pharmacia Earp's Youth at Work initiative, because as I sit here and think about that training, having a special focus on train the trainer for young people with disabilities would be really, really good, as well as, training for all youth at probably the high school level as they start, getting jobs in the summer during the school year and really begin building their resume and their career. It would be important to let them know as well. So thanks. That's actually helpful.
And just quickly, Chris, this is Andy again. One thing on the youth training that I think also would be helpful is helping young people know about the dangers of what's on your social networking site when you later are applying for jobs or for higher education or whatever you may be applying for. I think there's a lot of public information that's out there now about young people, some of which is genetic or health related. And I just think a lot of young people aren't thinking about that as they're building their Facebook pages or whatever it is.
No, you're right. That's actually a very good point. Well, thank you.
Thank you. Commissioner Barker.
And I just want to say, Mr. Imperato, I agree with your comments about Facebook and other internet sites, because not just from the standpoint of genetic information, but young people need to be aware of the general message they're sending about who they are for potential employers when they put some of these, photos on there that may be cute when you're 18, but when you're 25 and you're looking for a serious job, you're wishing it weren't on there. Several questions. One thing that I think Mr. Gruber brought up, might have been Ms. Baruch, but I think it was Mr. Gruber, about the whole issue of an employer's restrictions on the requirement now that when it comes to potentially hazardous workplace, that he cannot require testing, that it has to be voluntary. And you're pointing out, the challenges that presents from the standpoint of what an employer does with an employee who says no to that testing, and whether that employer has the right to reassign him, and particularly if there is no reassignment for which he's qualified that pays him at the same compensation level. And I'd be interested in hearing from Ms. Elliott and Ms. Vann of what you think an employer, what the balance is there. What employer has the right or should do when an employee says no, and yet an employer may be stuck in the situation of potential liability if he leaves that employee in that particular location.
Well, as a threshold matter, I think it should be recognized by all that an employer has the right, the duty, the obligation to run its business. Doesn't have the right to discriminate. I don't read GINA as imposing any reasonable accommodation requirement on employers, so I don't see an issue with an employer being able to transfer that person out as long as it's a legitimate, there's a legitimate business reason for doing so. There has to be a line drawn that continues to enable employers to do what they are supposed to be doing in terms of their actual business practice, and it cannot be the case that an employer can just be hamstrung in its ability to direct its workforce simply because someone refuses to move out of a job that or wants to move out of a job that poses some health risk or something like that with respect to this particular provision of the law.
Ms. Elliott?
And again, Karen Elliott. I think I'd like to understand a little bit better the circumstances. Are we talking about with an employer who perhaps works with hazardous materials, wants to make sure, get the employees tested to make sure that they are still healthy, haven't been exposed, don't have manifestations from whatever chemical or something such as that? Is that what you're referencing?
Yes, I mean, certainly not an employer who for no reason goes through and requests testing.
Well, and obviously I represent the employer's perspective on this, but I'm also an employee as well. And I think that as long as, I think an employer should be able to do that, but I think an employer needs to make sure that they have educated their workforce for why. I think that goes along with the educational requirements. I know, for example, we now have to educate in the workplace about ADA and non-harassment issues. So I can see an educational component in that way. Employees are educated about why this is happening and what their rights are. That if, just as in non-harassment, if you feel like your rights have been violated, there's a procedure, internal procedure that's built in to protect you as the employee. I can see that working out very similarly here if the employee feels that the employer has misused the test results in a manner. But I do believe that the two can work together for both the employees as well as the employer's benefit.
So are you saying that if an employer, if he has reason to feel that there may be a danger, would have the right to transfer that employee even if it means a lower level of compensation for that employee?
If it's a lower level of compensation, no, I think that they would have to, if the only reason, I think that would be discriminatory if the only reason was because of the genetic testing